Hello there. This is Erica Merrill. I'm the founder of Perfect Legal Video, and I am very happy to be here with attorney Joseph Nivin out of New York City. I know that you're all used to seeing us here on Friday afternoons by now, and we have another exciting topic. Today, we are going to be talking about objections to child support orders. And welcome and happy Friday to you. How are you today?
You too. Doing well. How are you?
I'm doing great. Now, Attorney Nivin is out of the office today, but he is diligent with helping us understand more about what happens in family court. So we're really glad that you're able to be with us.
Glad to be here.
Perfect. All right, so we'll get right into it. People spend a lot of time and money getting the decisions out of the court, and sometimes they don't like the outcome.
Mm-hmm. Right.
Someone doesn't like the outcome, I'm sure. There's always somebody that's unhappy. But what happens and what can you do if you get your orders for child support and you are not happy with the outcome?
So in family court, child support orders are issued by what's called a support magistrate. That is different from a judge. So when somebody does not like a child support order, what he or she can do is file what's called an objection, which is it's a document with arguments about why the support magistrate was wrong, and those go to a family court judge. So it's different from a normal appeal, where appeals are from orders of judges and referees, and they go to a whole separate court, which is called the appellate division in New York. But when a support magistrate issues an order and someone wants to challenge it, then those objections go to a family court judge.
Did you just say referees?
A referee is an attorney that works for the court system. They have most of the powers of judges, except that they cannot hold people in contempt unless it is a witness who's refusing to answer a question. Now, what's supposed to happen is that a referee hears a case and then writes a report for a judge to either confirm or not confirm. However, what most people do is simply consent to having the referee issue orders as if that referee were a judge. And in those cases, appeals from a referee's order go to the appellate division, not to a judge. But all orders from a support magistrate, when an order is issued by a support magistrate, then the way to challenge those orders is to file an objection, which goes to a family court judge.
Wow, that sounds exciting, and like I should have had a whiteboard out for that. All right, so you might have an objection, and you have a process where you can file that objection, and it will be heard either by the family court or by, did you say the federal court?
Well, the appellate division is different. Orders from judges are appealable to the appellate division. Same thing with orders from referees. With respect to child support orders, the only way that the appellate division would get involved is, there are two ways. One way is if somebody wishes to challenge a decision on an objection. So if somebody files an objection to challenge the support magistrate's order, and the objection is denied, meaning the support magistrate's order stays the same, then the person that filed the objection can then appeal the denial of that objection to the appellate division. Same thing where if an objection is granted and a support magistrate's decision is reversed, then the person that won before the support magistrate can appeal that order to the appellate division. Similarly, judges also get involved in child support matters when there's an order for incarceration where somebody failed to pay a child support order. A support magistrate cannot incarcerate the person, but a judge can. So what a support magistrate can do is recommend that a judge issue an order of incarceration, and those orders can also be appealed to the appellate division.
Wow, you almost forget that people can end up in jail over not paying their child support.
They can.
Yeah.
But the good thing for them is that they actually hold the keys to their own release, because the judge actually has to issue what's called an undertaking. which is like bail but for child support orders. So for example, if somebody owes $20,000 in child support, the judge may say, well, once you pay 10, then you get out.
I see. So then they're in there calling everyone they know.
Yes, absolutely.
That makes a lot of sense. So conversely, if I was in court and I had some orders that I agreed with, but now my ex is unhappy with the decision, what happens now if he files objections to what the final decisions were?
So when the other party files an objection, then you can file what's called a rebuttal, which is an argument for why it is that the support magistrate was correct. Now, if you don't file a rebuttal, and of course you can choose not to, then it doesn't mean that your ex automatically wins, but all that it means that the judge will only hear the arguments from your ex. So if you want your own side of the story to be heard by the judge, then you will need to file a rebuttal.
Wow, just sounds like more work after getting all those decisions.
Right.
So it's too bad, but I guess it's like anything else in court. You can always try to appeal it.
Yes, absolutely. And almost every order is appealable. There are some that are not, but for the most part, orders can be appealed.
Now, what can the judge do when he gets these objections?
Sure. So the judge can, of course, affirm the support magistrate's decision, meaning say that the support magistrate was correct. The judge can issue a new order. What the judge can also do is send it back to the support magistrate. So for example, if the judge didn't feel that the person filing the objection got a fair hearing for the support magistrate, the judge can send it back to the support magistrate with specific instructions about how to conduct the hearing.
Now, do they ever find that somebody was unwarranted and wasting the court's time and the money of their ex-spouse with constantly bringing them back to court?
Yes. So in child support cases, they can grant counsel fees to one party, and it's fairly common that they do.
Oh, yeah. I mean, so that makes a lot of sense. So if we are kind of along the same lines as that was my own personal question that I added, but do you have to go to court for these objections?
No. So those are done on what's called submission, meaning that an objection is filed, the other side files a rebuttal if they choose to do so, and then you get a decision in the mail. You don't have to go to court for the objection part of it.
Oh, wow. So what happens if the judge then rules in your ex's favor who is objecting to the original decision?
Well, it depends upon what the order is. If the order is an entirely new order, like for example, the judge lowers the amount of child support, then you can appeal that. But if the judge simply sends it back to the support magistrate, then you're back in the process that you thought ended.
Oh my gosh, so you almost have to start all over again.
Well, usually you don't have to start all over again, but they may direct that. Well, for example, and this did happen in one of my cases, the court simply felt that the support magistrate should have given more of an opportunity to the other side to defend himself. So he went back for one more appearance. He got his chance, and we got the same result. He filed another objection, and this time he lost.
Wow. Okay. So, I mean, I guess in the end, you're gonna hopefully, if it's a waste of time, you'll get your court fees back and your lawyer fees back. But,
right.
I mean, does this happen very often where the objections are overturn the whole decision?
No. For the most part, the objections affirm the decision of the support magistrate.
I see. So most of the time, the original decisions are upheld.
Yes.
I mean, because you're hoping that everyone's doing everyone they can to make things fair the first time around.
Right. And not only that, but also there are just so many people that appear unrepresented before support magistrates that it's very common for people that don't have attorneys to just kind of be angry, not really understand what went on in court, file objections on their own, and then they lose because they didn't really understand why it was that the support magistrate did the right thing.
I see. And so do you need an attorney for these objections when they come up on either side?
Yeah. Well, you can do one on your own, but people tend to be more successful when they have an attorney do it because they are actually based on legal arguments, and of course attorneys are trained to make legal arguments, whereas people that are not represented usually are not.
Well, that makes a lot of sense. I mean, I guess it's, people get tired of the whole process, but if this stuff is coming up, you want to make sure that you can save the decision if it was in your favor, or I guess if you're putting an objection together, if you have a really good reason for it, that you've got the best person out there arguing your case. And
right.
Especially since it seems like it's an uphill battle for those that are filing objections.
Right. Absolutely.
So my favorite part is always, do you have any interesting stories, or did we miss anything in the questions that we asked today? I know it's a little bit of a shorter topic, but it doesn't mean that it's any less important than some of the other things we've talked about.
Yeah. Well, the only thing that I would add is that with objections, it's not your time to make entirely new arguments. You have to argue about why it is that the support magistrate, with the evidence that he or she had before the court, was wrong to make the decision that was made with what was presented. I did once have a situation where I represented this woman. The father was also represented, and we actually came to an agreement with the help of the attorneys. We settled the support case and agreed on an amount that he was to pay my client. Unfortunately, he decided that he didn't like it, and he fired his attorney and wrote his own objection, which was really just a diatribe against my client. And needless to say, he lost. But yeah, that's just it really goes to show what can happen in family court, because there's so many people that are not represented. It's a very user-friendly court, which has its pros and it also has its cons.
I know, plenty of people that have just gotten a quickie divorce and did it themselves, and later on they kind of wish that they did get an attorney so that they could be represented properly. And honestly, it's for the rest of your life, or for the rest of the life of the child, you could be having a more detrimental way of raising that child if you don't have the funds that you need, and if you didn't do things right from the start in getting those things set up.
Right. Well, family court, New York is a little bit backwards in the sense we're unique in the nation, where family court is completely separate from Supreme Court, where people get divorces. So you can't go to family court and get a divorce. In family court, we have the orders of protection, we have custody, we have child support, abuse and neglect, we have paternity and juvenile delinquency, we have PINs. And then to get a divorce, you have to go to the Supreme Court. Now, family court is very user-friendly, and that it's very easy for someone to go there and file for an order of protection on their own. Same thing with filing for custody and filing for child support. In Supreme Court, it's not terribly difficult to file for a divorce on your own. As far as getting the divorce, if it's not contested, they will give you a packet, which is overwhelming for most people. It's very common for people that are pro se and even attorneys to have their papers bounced. But as far as contested divorces where you need a judge to make a decision about custody or maintenance or child support or any of the other things that come up, you more often see people appearing with attorneys.
Wow. Now, I guess I have another question, though, about the child support. Isn't there a calculation and people just get what the calculation is? Or how can people fight over that if there's something that's kind of set up already?
Well, there are a few ways. There is a formula, and child support proceedings are very simple when both people are middle class, and there's no dispute about income. But where the fights come in are a few different ways. So first of all, the most highly contested child support cases are ones where income is in dispute. That generally means where at least one of them is self-employed. So for example, if someone comes in saying, I own a business and I make $30,000 from the business, and the other side says no because you write off things that are actually personal expenses and you make a lot of money off the books. Another way is with what's called the cap. So the formula only goes up to a combined parental income of $148,000 per year. Now, if the combined parental income is above $148,000 per year, then the court can decide what the cap is. It's based upon the needs of the child. So if, for example, we have a couple that makes combined income of $300,000 per year, then the custodial parent, the one that will receive child support, might want a cap of closer to $300,000, whereas the non-custodial parent might want a cap of closer to $148,000. Furthermore, there are what are called deviations, meaning that there are actually times when the court does not have to apply the formula. An example might be if one parent makes significantly more than the other parent, or if one parent has educational expense like student loans, or also if the non-custodial parent says that during his or her parenting time that he or she has such expenses for the child that it actually saves the custodial parent some expenses during the time the child is with that parent. Another issue that comes up a lot is childcare. So the childcare is actually above what's called the basic child support. That's separate from the formula. So if a parent under the formula is paying basic child support of, let's say, $1,200 per month, then on top of that, then the non-custodial parent will have to pay childcare expenses if the custodial parent needs the childcare to work or to try to get employment, including going to school to get it. So very often what we see fights over is what is a reasonable amount of childcare. So on an extreme end, if a child has 2 nannies, then the support magistrate might not have the freedom to actually order contribution to both nannies. On the other hand, if all that is a daycare that charges market rates in that area, then most likely the non-custodial parent will have to pay what's called a pro rata share, a certain percentage of that daycare expense.
Okay, I see. So it sounds like it's kind of a complicated issue. It depends on the different situations, which I think makes it even more important for you to have an attorney helping you navigate those waters.
Yes, in situations like the ones I just described, it's certainly advisable to go with an attorney.
All right, so those were great examples. I really appreciate your bringing more light to some of these custody battles and objections after decisions are made. And it's fantastic that you're here with us on a Friday again. We really appreciate you and all the information that you give us. And I want to just thank you again and wish you and everybody out there a fantastic weekend.
Same to you. Thanks for having me.
All right. Thank you so much. I will look forward to talking to you next Friday.
Talk to you then.
All right. Bye now.
Bye-bye.